Supreme Court just handed down a 9-0 unanimous decision that should have settled everything. Not 8-1, not 7-2. 9 justices all agreed that the government went too far. And yet at this very moment, the Department of Justice is back in federal court, arguing the exact same points that 9 Supreme Court justices just rejected, trying to convince a lower court to ignore what the highest court in the land said and let them off the hook anyway. This is not a legal technicality. This is not a minor procedural dispute. This is about whether federal agents can kick in your door by mistake, realize they got the wrong house, traumatize your family, and then walk away without any consequences by simply claiming they were exercising discretion. If that sounds like something out of a police state, it should. But that is exactly what the government is arguing right now in a case that could determine whether there is any real accountability when law enforcement gets it catastrophically wrong. Let me take you back to where this nightmare started, because the facts are so shocking that you would think the case would have been over years ago. It is early morning in 2017. The sun has not come up yet. A family is sound asleep in their home in a quiet suburban neighborhood outside Atlanta, Georgia. Katrina Martin lives there with her boyfriend and her young child. They are not criminals. They have no gang connections. They are not under investigation. They are ordinary people living ordinary lives. But at some point before dawn, the front door of their home explodes inward. Federal agents in full tactical gear flood into the house. Flashbang grenades detonate inside the rooms. The sound is deafening. The light is blinding. Guns are pointed at terrified people who just woke up to what feels like a war zone erupting in their own living room. Katrina Martin is dragged outside half naked in front of her neighbors, while armed agents secure the house and detain everyone inside. Her boyfriend is forced to the ground. Her child is screaming in terror. And then, after all of that, after the door is destroyed and the family is traumatized and the entire neighborhood is watching federal agents standing in someone's front yard, the FBI realizes something. They are at the wrong house. The address they were supposed to hit was 3 doors down. 3 doors, not 3 blocks. Not a different street, 3 doors away on the same street. The target was a residence where suspected gang members were believed to be operating. That was the house on the warrant. That was the address they were supposed to raid. But instead of following the address printed on the legal document authorizing the search, federal agents relied on a personal GPS device, probably someone's phone. And that device led them to the wrong house, so they kicked in the wrong door, threw military-grade grenades into the wrong home, pointed guns at the wrong family, terrorized the wrong child, and destroyed the sense of safety and security that the Martin family had in what was supposed to be their sanctuary, all because someone trusted their phone instead of reading the warrant. Now you would think that when something like this happens, the government would immediately apologize. You would think they would compensate the family for the destroyed door and the emotional trauma and the violation of their home. You would think they would take responsibility for what is clearly a catastrophic failure in the most basic aspect of executing a search warrant, which is going to the right address. But that is not what happened. Instead, the Martin family had to sue the federal government. They filed a lawsuit under a law called the Federal Tort Claims Act. The FTCA is the statute that allows American citizens to sue the federal government when its employees commit wrongful acts. It exists specifically to provide a legal remedy when government agents violate your rights or cause you harm through negligence or misconduct. The entire purpose of the law is to make sure the government can be held accountable just like any private citizen or private company would be held accountable for the same conduct. But the FBI and the Department of Justice did not want to be held accountable, so they invoked something called the discretionary function exception. This exception is a shield built into the FTCA that protects the government from being sued when its employees make decisions that involve policy judgments or the exercise of discretion. The idea behind the exception makes sense in theory. You do not want courts second-guessing legitimate policy choices made by government officials who are trying to do their jobs in good faith. For example, if federal agents decide to raid a house at dawn instead of noon because they believe dawn is tactically safer, that is a discretionary policy decision. You do not want a judge or jury substituting its judgment for the professional judgment of trained agents about tactics and timing. That is a reasonable protection. But here is where the government took that reasonable principle and twisted it into something absurd and dangerous. The FBI argued that how the raid was planned involved discretion. They claimed that decisions about surveillance, navigation, and approach tactics were all discretionary choices. And because those decisions involved the exercise of discretion, they said the discretionary function exception applied, and the family could not sue. Let that argument sink in for a second. The government's position was that getting the address wrong was protected by the discretionary function exception because identifying the correct house involved discretion. In other words, they were claiming that federal agents have discretion to raid the wrong house, and if they do, you cannot sue them because that mistake flowed from a discretionary decision about navigation and identification. That is not a policy judgment. That is just being incompetent. And the government wanted total immunity for incompetence. The district court bought the argument. The trial-level federal court ruled in favor of the FBI and dismissed the case. The Martin family appealed to the 11th Circuit Court of Appeals, which is the federal appellate court that covers Georgia, Florida, and Alabama. The 11th Circuit also ruled in favor of the FBI. 2 courts in a row said that raiding the wrong house was protected by the discretionary function exception, and the family had no legal remedy at all. So the Martins took the case to the United States Supreme Court. And the Supreme Court agreed to hear it, which is significant because the court only accepts a tiny fraction of the cases appealed to it each year. The fact that they took this case signaled that something was seriously wrong with how the lower courts were applying the law. And then the Supreme Court ruled 9-0, unanimous. Not a single justice sided with the government. Justice Neil Gorsuch wrote the opinion for the court, and he made it crystal clear that the 11th Circuit had applied the discretionary function exception far too broadly. The court said that just because law enforcement exercised judgment does not mean they automatically get immunity. You have to show that the judgment was grounded in legitimate policy choices, not just any decision, not just any exercise of discretion. It has to be an actual policy judgment about how to carry out government functions. The court told the 11th Circuit to go back and take a fresh look at whether the FBI's actions were actually protected under the law. In plain English, the Supreme Court was saying, you got this wrong. Go back and apply the law correctly. Do not just rubber stamp government immunity because agents made a decision. Figure out whether raiding the wrong house because you trusted your phone instead of reading the warrant is actually a policy judgment or just a screw-up that should not be protected. You would think that would be the end of it. 9-0 loss at the Supreme Court. Clear instructions from the highest court in the land to apply the law correctly. The case goes back to the lower court, and the family finally gets their day in court. But that is not what is happening. Instead, the Department of Justice under the Trump administration filed a new brief in the 11th Circuit, arguing that the case should still be dismissed. They are asking the 11th Circuit to throw out the case even after the Supreme Court ruled unanimously against them. And the arguments they are making right now are essentially the same arguments they already made. They just repackage them with slightly different language. The DOJ is claiming that the agent's mistakes flowed from discretionary decisions about surveillance, navigation, and approach tactics. They argue that no statute or regulation specifically dictates exactly how federal agents must identify a home before raiding it. And because there is no specific rule spelling out every step, they had discretion. And because they had discretion, the discretionary function. Exception applies. And because the exception applies, the lawsuit should be dismissed. It is the same circular argument. They are just wording it differently and hoping the 11th Circuit will ignore what the Supreme Court just said. But the Martin family is not backing down. They filed a response brief that absolutely dismantles the government's position. And their arguments are powerful and straightforward. First, they argue that executing a warrant at the correct address is not a policy decision at all. It is what lawyers call a ministerial duty. A ministerial duty is a task that involves no discretion whatsoever. You just do it. There is no judgment call involved, no policy balancing, no tactical considerations. You have a warrant. The warrant has an address printed on it. You go to that address. That is not discretion. That is basic competence. That is reading. Federal agents do not have discretion to raid the wrong home. They do not have discretion to ignore the address on the warrant. They do not have discretion to trust a phone app over the legal document that authorizes the search. There is no policy judgment involved in getting the address right. It is the most basic requirement of executing a search warrant. Second, the family argues that the discretionary function exception was designed to protect actual policy judgments, not reckless operational failures. The exception exists, so courts do not micromanage how government officials make legitimate choices about how to carry out their duties. It does not exist to shield agents from liability when they ignore the warrant and kick in the wrong door. Raiding the wrong house is not grounded in any legitimate federal policy. There is no government policy that says sometimes we raid the wrong house, and that is acceptable. There is no discretion to terrorize innocent families who have nothing to do with the investigation. The exception does not apply to mistakes that have nothing to do with policy and everything to do with negligence. Third, the family argues that once the shield of the FTCA is removed, all the normal rules apply. If a private person would be liable under state law for this type of conduct, then the United States government is liable too. That is how the FTCA works. It waives sovereign immunity and subjects the government to the same liability as a private individual or private company. And under ordinary tort law in the state of Georgia, if you kick in someone's door by mistake and terrorize their family, you are liable for damages. If a private security company did what the FBI did, they would be sued into bankruptcy. The family would win and the company would pay. The fact that it was federal agents instead of private security does not change the legal analysis under the FTCA. Wrong is wrong regardless of who does it. Fourth, and this is the most important argument the family points out, that the DOJ's position would create catastrophic consequences for everyone in this country. If the government's argument is accepted, it means that any law enforcement raid could be insulated from lawsuits simply by labeling the mistake as discretion. Wronghouse raids would be completely immune from accountability. Victims would have no legal remedy, no matter how reckless or negligent the conduct. It would not matter if agents ignored the warrant entirely. It would not matter if they relied on obviously faulty information. It would not matter if they destroyed your home and traumatized your family. As long as the government could claim the mistake involved some exercise of discretion about planning or tactics or navigation, you would have no case. That would expand government immunity far beyond what Congress intended when it passed the FTCA in the first place. It would create a loophole big enough to drive a tank through, and it would directly contradict what the Supreme Court just said in a unanimous 9-0 ruling. So where does that leave us right now? The Supreme Court issued a unanimous decision that narrowed the scope of government immunity in cases like this. The DOJ is still trying to preserve immunity anyway by repackaging the same arguments that already lost at the highest level. The Martin family is pushing back hard and pointing directly to what the Supreme Court said. And the 11th Circuit now has to decide whether wronghouse raids are protected policy decisions or unlawful negligence that should result in liability. This case is no longer just about one family in Georgia. It is about whether federal agents can be held accountable when they invade the wrong home, or whether the government can always escape liability by claiming that mistakes are just discretion. The Supreme Court made it very clear that the lower court must draw a real line here. They cannot just hand the government a blank check for immunity every time an agent exercises any judgment. They have to take a fresh look at the case and apply the law correctly based on that 9-0 ruling. The 11th Circuit has now scheduled oral arguments for the week of March 23rd. That is when both sides will stand before a panel of judges and make their case in person. The DOJ will argue that the FBI should still be immune from this lawsuit. The Martin family will argue that immunity does not apply to basic operational failures like raiding the wrong house. And the court will have to decide who is right. But here is what makes this moment so frustrating and so important. The Trump DOJ is doubling down on arguments that have already been rejected by every single justice on the Supreme Court. They are not offering new legal theories. They are not presenting new evidence. They are not acknowledging that maybe they should rethink their position after losing 9-0. They are just repackaging the same arguments and hoping the 11th Circuit will give them a pass. That is not how the legal system is supposed to work. When the Supreme Court rules unanimously against you, that is a pretty clear signal that your legal position is wrong. But instead of accepting that and moving forward, the government is fighting tooth and nail to avoid any accountability whatsoever. And this matters for every single person in this country because if the government wins this argument, it sets a precedent that affects all of us. It means federal agents can make egregious mistakes and hide behind immunity. It means your home could be raided by mistake, and you would have no legal recourse whatsoever. It means the government can kick in your door, terrorize your family, and then walk away by claiming they were exercising discretion in how they planned the raid. That is not the America we are supposed to live in. That is not what the Constitution is supposed to protect. And that is absolutely not what the Supreme Court just said is allowed under federal law. So everyone needs to be watching this case very closely. When oral arguments happen in late March, we will see how the 11th Circuit responds. We will see whether they follow the Supreme Court's clear instructions or whether they try to find a way to give the government what it wants anyway. And when a decision is issued, we will know whether federal accountability is real or whether it is just a concept that disappears the moment the government decides it does not want to be held responsible for its mistakes. The Martin family has been fighting this case for years, going through multiple levels of courts and facing a federal government with unlimited resources and unlimited lawyers. But they are still fighting, and their fight matters because it affects all of us and the kind of country we live in.